Annex 6. Here again, for Zvornik. There are 2 pages because it's quite extensive. Paragraphs in the indictment on the left-hand side, paragraphs in the pretrial brief from 91 to 94. Then you have all the footnotes and all the witnesses who testified for Zvornik with their number and so forth and so on. And you could all this is at your disposal, and you can take a look at it and scrutinize it. It'll probably take you hours to peruse through it. Annex 7, Greater Sarajevo region, paragraphs in the indictment, paragraphs in the pretrial brief, footnotes, witnesses and documents. Then this page is the second page for Sarajevo. Then Mostar, Annex 8. One page was enough, was sufficient. In the pretrial brief, paragraphs 109 to 116, footnotes, and you have the list of all witnesses who came to talk about Mostar. You have all the necessary reference here. Appendix 9, Nevisinye. There again, this tedious work made it possible to illustrate all paragraphs in the indictment and in the pretrial brief. To see what footnotes and witnesses and documents correspond. And I refer to document P31, which is the testimony of Mr. Šešelj under oath in the Milosevic case. And you have the transcript references, of course, in the Milosevic case, the French Milosevic case, the French transcript, which I read extensively. Appendix 10, Herchkovki. This is a very important city. You have the paragraphs in the indictment, paragraphs in the pretrial brief, 122 to 129, because there's an additional page. Thank you. The witnesses who came to testify. As you see, there are many of them, and you have their numbers. I will now move on to Appendix 11, and I'd like to thank our usher, who's very effective and helps us to save time. Let me explain something to Mr. Markusen and Mr. Šešelj. This chart gives a list of all Croat victims who, according to the prosecution, were deported or forced to leave the area, to leave either to Croatia or elsewhere. There are several hundreds of these people. There's 28 pages of this annex. On the right-hand side, I deduct all mentions of people whose destination is unknown. For example, number 4, 18, 19, and 21. On page 2, 26, 27, 28, 33, 34, 36, 40, 43, 47, and 48. For some of these people, we know for sure that they did go to Croatia and Zagreb. But for others, in the document, all that is stated is destination unknown. We don't know. We don't know whether they left. We don't know whether they left because they were expelled or because of a forcible transfer, whether they left of their own volition. There's a doubt. Because of this, I delete from Appendix 11 233 people, which means that should Mr. Šešelj be found guilty, as far as I'm concerned, he should be acquitted at least for the victims who are listed on the right-hand side column, because I have no element at hand to know whether these people actually left Hrtkovski or not. We don't know where they went.
Alors, j'en viens à l'annexe 12, qui est...
And Appendix 12, which was what I had regarding the mosques and the Catholic churches. You see there's a table: key, SD severely damaged, PD partially destroyed, CD completely destroyed, and AB adjacent building. Each letter gives us a qualification. I divided the religious property into two categories: Muslim sites and Catholic sites. I made a list of all the religious property which were severely damaged, first column, or partially destroyed, second column, or completely destroyed, third column. To give you an example, you see that the convent of Franciscan sisters was severely damaged. But the Church of St. Peter and St. Paul, 19th century, was partially destroyed. This is an annex. This is for Mostar on this page. Next page, we have Nevesinje. Here, for Nevesinje, as far as totally destroyed, completely destroyed, you have them here. And for example, you see that the Islamic archives were completely destroyed. That's on the right-hand column. Then Zvornik. This is very tedious work. Was done, building by building. And you have the conclusions I drew regarding either the total or partial destruction of these sites. For example, you see that the 18th century mosque of Begusha was totally destroyed in Zvornik, completely destroyed. And the list goes on. Obviously, there was a huge amount of religious buildings in this city. We'll now move to the Sarajevo region. Novigrad, Novo Sarajevo. You have a list of the buildings here. Vogoška. There again. The buildings are divided according to the destruction they incurred. On this page you have Vogosha and Iliash. The list for Iliash continues on the next page. Next chart. No, we've seen everything. We have here on these charts all the evidence that could establish the commission of crimes. The next question now is who these crimes should be attributed to.
Pour cela, je suis amené.
In order to do so, I must mention paragraph 4, individual criminal responsibility. Modes of responsibility. In paragraph 130 of the pretrial brief, the prosecution asserts that individual criminal responsibility of Vojislav Šešelj is incurred in the counts of the indictment pursuant to Article 7.1 of the statute that quotes paragraphs 5 to 14 of the indictment. As far as commits is concerned, Vojislav Šešelj is prosecuted for having participated in the JCE and also for having physically committed the crimes of persecution through hate speeches as part of the incidents that occurred in Vukovar, Croatia, and Zvornik, BiH, and Herkovci, Vojvodina, Serbia, and B, the crimes of expulsion and forcible transfer as part of the incidents that took place in Herkovci. As far as direct responsibility of the accused is concerned, I must address the forms of responsibility of the accused. These forms each in turn according to the following outline: planning, instigating, ordering, committing. As part of the JCE, individual commission of crimes of persecution, deportation, and forcible transfer, and aiding and abetting. I shall, after I have delivered my reasoning, enter a judgment of acquittal on several counts of the indictment. Planning. The prosecution, in paragraphs 143 of the pretrial brief, avers that the accused planned the crimes of persecution, murder, torture, cruel treatment, deportation, forcible transfer, wanton destruction, and plunder of private and public property in Vukovar and Zvornik. Counts 1, 4, 8, 9, 10, and 14. 10 to 14. Paragraphs 15 to 18, 20 to 22, 24 to 26, 26 to 34 of the indictment. And the crimes of persecution, deportation, and forcible transfer at Herkovci, counts 1, 10, and 11. Paragraphs 15 to 17, 31 to 33 of the indictment. The prosecution submits that the mens rea element involved in the planning of the crimes in Vukovar and Zvornik results from his inflammatory speeches, to the fact that he approved the sending of his volunteers in these areas when he knew that they had committed criminal acts on the battlefields. Third point, from the fact that these crimes did in fact take place or were committed. The prosecution adds that as far as Herkovci is concerned, the mens rea involved in planning is exemplified by the statements made by witnesses VSO 14, VSO 26, VS 1133. I hold, first of all, that planning implies at its lowest a plan, and an architect of that plan, all the more so that in Vukovar, the intervention of the GNA could only take place after a decision at a very high level had been taken involving the military command, and that in this context, the political opponent in the person of the accused played no part in the planning. The fact that volunteers were present in Vukovar or sent to Zvornik is not per se enough to state that he planned or that he was involved in the planning or that he was a perpetrator in the planning. As far as Hetkovsky is concerned, the accused did not plan the deportations or the persecution campaign himself. It is important to note that at the time he delivers his speech, and for those people who have forgotten about it, this was on the 6th of May 1992. He was on a campaign trail and had no means of coercing the civilian population in his capacity as a possible main perpetrator of the planning. The mens rea element involved in planning cannot be directly drawn from the inflammatory speeches, for a sufficient nexus cannot be drawn between words uttered in Vukovar, which is far from having been established, and a meeting in Mali Zvornik, which did not take place at the date specified by the prosecution, in my view. I hold, secondly, that the fact that the accused approved of the sending of volunteers does not mean that he knew that some of them were going to commit crimes on the ground. In this respect, it is important to make a distinction at the moment in time when the volunteers were sent spontaneously, Borovoselo, and the sending of volunteers at the request of Slobodan Milosevic in a legal fashion. Furthermore, as things stand, there is insufficient evidence to prove that a member of an SRS, a volunteer member of the SRS, committed a given crime. The fact that the alleged crimes took place does not mean that these crimes had been planned beforehand. It is alleged in the indictment and the pretrial brief in several instances that volunteers of the SRS, Šešelj's men, did participate in the commission of multiple crimes. If it's true that several witnesses, either in the statements they gave to the OTP or during their testimony before the chamber, mentioned the existence of SRS volunteers, Šešelj's men, a reasonable trier of fact must nonetheless, to establish what one or person has said, have material and undisputable evidence. First piece of evidence, which should be undisputable, the military booklet of the volunteer, which mentions his assignment to a given post and to a military unit, identified with the initials VP and followed by a number. Refer to Goran Stoparic's witness testimony on the 15th of January 2008 at the hearing held in open session where he explained all of this to us. The second mens rea element, which should be cross-referenced with the first element, is the membership card of the SRS, which each party member had. The second material element, interpreter's note. Without such cross-referencing of these two elements, a reasonable trier of fact cannot conclude that a given volunteer assigned to a given unit having committed a given crime was a volunteer of the SRS. Furthermore, the numerous testimonies of prosecution witnesses, photos and videos adduced and admitted by the trial chamber lead to the conclusion that any fighter was wearing patchy clothing, and this does not mean that this qualified him as a member of a particular unit in the absence of any insignia or distinctive sign identifying the unit. Likewise, some of them wore the sash kasha, others did not, or wore a helmet, or had no helmet and no sash kasha. It is clear that, in light of the evidence that has been admitted, each volunteer was submitted to a military chain of command, which was not, in my view, the chain of command of the SRS. I hold, therefore, that the accused should be acquitted on this mode of responsibility based on planning.
Alors, je regarde l'heure, il doit...
I'm just looking at the clock. We have approximately 10 minutes left. I believe that in 10 minutes' time, I will have time to read 3 pages. I will have then completed 1/3 of what needs to be done. Instigation. The Chamber in its majority has decided to only look into this mode of responsibility. I myself review all modes of responsibility. The prosecution in paragraphs 146, 147 and 148 of the pretrial brief ascertains by relying on various judgments and appeals judgment, Kwaszka, Kodic, Blaskic, Kelsic, Nahimana, Berjanin, Akayesu, that the accused instigated the crimes of persecution, murder, torture, cruel treatment, deportation, forcible transfer, wanton destruction, and plunder of private and public property in Vukovar and Zvornik. Counts 1, 4, 8, 9, and 10. 10 to 14, paragraphs 15 to 18, 20 to 22, 24 to 26, 26 to 34 of the indictment. And the crimes of persecution, deportation, and forcible transfer in Hertkovsky, counts 1, 10, and 11, paragraphs 15 to 17, and 31 to 33 of the indictment. Through inflammatory speeches he delivered when he visited these localities or other neighboring localities like Mali Zvornik. As far as the words uttered by the accused in Vukovar is concerned, it so happens that the evidence adduced does not prove that the accused uttered these words. In fact, witness VS027, on reviewing his testimony, or when I reviewed his testimony, realized that he is not entirely credible. All the more so that in the Merkšić, Radić, and Slevančanin judgment that amounts to res judicata, it is mentioned in paragraph 51 the following. I shall read it out. It seems a point of interest. The trial chamber reserves the right to address this in greater detail in its judgment. The chamber is not persuaded of the honesty or reliability of the witnesses who testified about this. Their evidence in this respect is not confirmed by other evidence, and in addition, there is contradicting evidence regarding Miroslav Radić and Veselin Slevančanin's presence at this meeting. The chamber records at this stage that it accepts that Vojislav Šešelj visited Vukovar on several occasions in late October and early November 1991, but is unable to conclude on the evidence it has heard that Radić and Slevančanin attended a meeting at which Šešelj made such a statement. There is an element of doubt, in my view, and this benefits the accused, of course. As far as the speech delivered at Mali Zvornik is concerned, alleged in paragraph 93 of the pretrial brief, address by the sole witness VS017, quoted in a footnote on page 292, the witness seems uncertain about the date. The confusion may arise from the fact that another speech was delivered in August of 1990. As far as the speech delivered at Chertkivsky on the 6th May 1992 is concerned, mentioned in paragraph 127 of the pretrial brief, the statements of a witness VS1133, quoted in the form of a footnote on page 441, do not seem credible. All the more so that the speech that the chamber has received does not mention his statement in any way. Let me remind you of the words purportedly uttered by the accused, that mixed marriages needed to be purged, mixed marriages between Serbs and Croats, and that the children of this union should be killed. VS133, line 10624 and 10664. These statements do not figure in the official speeches we have received. However, the speech delivered at Chertkivsky, through the words spoken, fall within the scope of counts 1, 10, and 11 of the indictment, under instigation to commit persecution, deportation, and forcible transfer. At this stage of the trial, it cannot be determined whether under counts 1, 10, and 11 of the indictment, the accused Šešelj incited or instigated or committed, for either he instigated or he committed. He can't, in my view, be both an instigator and a perpetrator. It's either one or the other. Therefore, irrespective of this issue, the prosecution has adduced enough evidence on the instigation of crimes of persecution, deportation, and forcible transfer at Chertkivsky. However, he should be acquitted on the crimes of murder, torture, cruel treatment, wanton destruction and plunder. That said, the documents quoted by the majority, P1264, P1259, P1257, P1192, P1293, P0685, P526, P528, P1298, P1200, P1180, P1324, and the witness testimonies of VS016, VS033, Stojanovic, Bosanac, and VS004 seem insufficient to establish a nexus between the instigating statements the accused is charged with and the crimes listed under counts 4, 8, 9, 12, 13, and 14 of the indictment. I will finish in a few minutes' time. I should also mention in greater detail counts 8 and 9 on torture and cruel treatment. In the majority, the bench relies on witness VS1032 to establish the commission of the crimes in Zvornik. If it is true that the head of the unit, Šešelj, mistreated and killed detainees, and that he was a volunteer that had been proclaimed voivode, and that other volunteers headed by a so-called Repic had committed torture and cruel treatment in the municipality of Zvornik, this does not mean that a reasonable trier of fact can draw the conclusion that these acts were committed on the instigation of the accused Šešelj. Undisputable or compelling evidence, such as documents or statements establishing a positive nexus between the crimes and the accused, is required. The Chamber in its majority found that sufficient evidence was adduced with regards to count 8 and 9, instigation in Vukovar, Beglofer, VS1051, Vojnovic, VS016, Zvornik, VS1012, VS1013, VS1064, VS1065, P307, P389, P469, Sarajevo, VS1055, P455, P457, Nevesinje, VS1022, VS1051, Mostar, Karicic, Bilic. If a reasonable trier of fact could conclude that torture and cruel treatment were in fact committed, there is nonetheless not sufficient evidence to establish a nexus between the accused Šešelj and these crimes for instigation and this form of responsibility. As an example, what words uttered led in the mind of the perpetrator of the crime to brutal and inhuman living conditions for civilians in the basement of the Kilavsky thermal plant. Witness VS1022 ascertains that this occurred, that no one doubts. But what are the reasons for that? The words uttered by the accused or any other reason?
Là aussi, j'ai un doute.
There again, I entertain doubt as to counts 7, 8, and 9, instigating to commit murders. Tomorrow, I'll look into ordering, and I will, at great length, develop another topic. Forgive me for that, but it is essential. I will address the issue of the joint criminal enterprise. And may as well tell you straight ahead beforehand, because this may give you food for thought overnight. I find that Mr. Šešelj was not a participant in a joint criminal enterprise together with Milosevic, Karadzic et al. But all this will be proven and demonstrated tomorrow based on a very lengthy reasoning that is going to be quite time-consuming tomorrow. So there it is. I've got to page 25. We've got 50 pages for tomorrow. The rest assured, we won't have to work until midnight tomorrow. This being said, I wish you all a very good evening. We shall reconvene tomorrow to go on with the reading.
All right, we will be.